to get in.
He's not in the waiting room at the moment.
Yeah, he had texted me that he was on, that he had a screen that was up, but that screen did not allow him to get in with the link that I provided him.
Counsel, do you want to go off camera for a while until you can get him?
I can do that. I sent the link that was sent to me yesterday, so I don't know if there is a separate link that I need to send to him.
No, there's not.
No.
Okay.
I think this is him. It's iPhone and a phone number. So he must be logging on with his phone.
All right, we have an iPhone on 202-352-3651. Is that respondent, Ms. Pauling?
Yes, ma'am.
Okay, thank you. I'll just remind everybody to minimize background noise if you're not actually speaking, to put your microphone on mute. All right, so we'll begin. Today is Thursday, January 25th, 2024. The Board on Professional Responsibilities convened in the matter of Michael Alexi, board docket number 21BD050. Will the parties please identify themselves for the record, starting with disciplinary counsel?
Jack Metzler for disciplinary counsel.
And Kristen Paulding for Mr. Alexi.
And we understand Mr. Alexi is present.
Yes, I believe he's logged in.
Okay, the board reminds the parties to please not state the client in this matter, initials MT, to not state that person's specified medical condition during the oral argument. And you can refer to the board protective order that was filed on June the 3rd, 2022 in this matter. Instead, please use the term medical condition or a similar term to refer to that. So we're here on the exceptions to the hearing committee report from respondent, who will proceed first. You'll have 20 minutes. Do you want to reserve some of your time for rebuttal, Ms. Paulding?
Yes, may I reserve 5 minutes?
Sure. Okay, so you may proceed.
Good afternoon. I am here on behalf of Mr. Alexi, who has filed exceptions to the hearing committee report that found that he violated 1.6a by knowingly revealing client secrets. What I'm asking the board to do in this case is to look specifically at disciplinary counsel and whether or not they proved by clear and convincing evidence that there was a violation of this rule. In reading the hearing committee report, I see that the hearing committee focused a lot on the body of the withdrawal notice. But I'm going to ask the board to go further and to examine the testimony of the client, in this case, MT, in addition to that withdrawal notice, to determine whether or not we had a knowing revelation of secrets in that case. Specifically, I want to start with what a secret is, because disciplinary counsel had an opportunity through the client's testimony to prove that the information in the withdrawal notice was secrets, or were secrets, and they simply did not do that. So the definition of a secret has essentially 3 different parts. The first is that the information has to be gained in the professional relationship. And for the purpose of this argument, I'm going to assume that all the statements in the withdrawal notice were gained as a part of the professional relationship that Mr. Alexi had with the client. So then there are 3 other things that have to be shown in order for that information.
Excuse me, counsel. I have a question. Since you're focusing on reveal and secrets, my question to you is, has the court ever endorsed your definition of reveal and secret?
Well, there is a specific definition of secret in the rule. That's what I'm focusing on now. I understand that in my exceptions report, I did utilize plain language because I think that that should be part of the consideration, but secrets is specifically defined in Rule 1.6a. And if this board looks at that specific definition, I think you will see that disciplinary counsel did not meet its burden. The
But
plain
I'm going to
language.
look at the court's definition of reveal in secret as opposed to what you propose?
No, I think that the plain meaning of those things should also be utilized when reviewing the case in its totality. But I acknowledge that secrets is specifically defined in Rule 1.6. And that is that it has to be information gained in the professional relationship, and then one of three things has to occur. Either the client has to request that it be held inviolate, which that did not happen, or the disclosure has to likely be embarrassing or likely be detrimental. And those are the two things that the hearing committee largely focused on.
Okay,
in-
excuse me, one question. So in your brief at page 9, it states that the withdrawal notice was not an embarrassment, that she was instead offended because the doctor had not come to a final conclusion on the diagnosis. So what is your support that offended does not equate to embarrassed under the definition of Rule 1.6B secret?
Well, they're two different words. I mean, I can be embarrassed by something and not offended by it. I mean, if I fall down the stairs because I'm wearing high heels and in front of the court, I've, hit my face, I'm going to be very embarrassed. But nothing has happened that has offended me necessarily. And this is the important point about that. There are roughly 35 or so pages of testimony in which MT had direct and cross-examination, in which disciplinary counsel had the opportunity to use the very specific language that is listed in secrets. They could have used that word embarrassed, and they could have asked that client, okay, let's go through the withdrawal notice and these statements step by step. Did
So,
statement 1 embarrass you? Did
I have a
statement
question. Are you familiar with the Osemeni and the Gonzalez matter, those two cases?
Yes, ma'am.
Okay, so are you able to distinguish the facts of this case from those two cases? And how do you reconcile the difference with the conduct that is being alleged was violated?
Well, Gonzalez reveals extremely private information about the client that is not the same thing that you have here in this client's case. So when you have Gonzalez, that particular attorney was sending a withdrawal notice to opposing counsel that revealed he wasn't being paid. It revealed that his client was lying to him and not cooperating with the defense. Information that client had revealed to him through their private meetings, but ultimately that information was not known to the court. There was no reason for the court to know that that client didn't pay or that that client was being untruthful. That's not close to what we have here. What we have here is 6 years of documents that are being filed in a private, with a private agency. USCIS is not making their files public and open to anyone that wants to review them. Here we have.
Isn't it an attorney's duty of confidentiality applies to not only privileged confidences, but also to unprivileged secrets that exist without regard to the nature or source of the information or the facts that others share the knowledge?
Agree that that's the rule, but then disciplinary counsel has to prove that. So when we have this hearing in June of 22 and the client is on the stand, you should have asked the question, which of these statements embarrassed you or were detrimental to you? And none of that evidence was presented. So what the hearing committee is doing is they're looking at the document on its face, when really the individual who would have been embarrassed or harmed by these particular statements is sitting right there and can offer that evidence and was never asked the questions. The initial bar complaint.
So Ms. Paulding, are you saying that, and I think this is what you just said, that the hearing committee's findings are based on its inferences from the document and not from testimony that was elicited from the complainant?
Yes, ma'am. And that's because the questions were never asked. And I think that's important to note because it's not like this client wasn't there. Let's say, for example, she wasn't present or she had maybe been deported or didn't have her visa renewed, and they didn't have the opportunity to actually ask her how she felt about those things. I think her first statement was that everything that he wrote in the withdrawal notice was correct. I think that's on page 41 of the transcript. She said, I definitely understood what he wrote. She was offended because the diagnosis she felt was incorrect. And from all of the exhibits I presented, that diagnosis had changed over time, and various doctors had listed different diagnoses. So the interesting part to me, and this is probably a better question for disciplinary counsel, is why wasn't it asked? She's right there in front of you. She files a bar complaint because documents were not provided to her. And Mr. Alexei responds in kind by saying, I've provided these documents and I withdrawn from her case. Why would he provide that withdrawal notice voluntarily in responding to a disciplinary counsel matter if he thought that he had done something wrong or violated the rules, or that she had a problem with it? It was sent to her. She had no problem with it whatsoever. And
Excuse me,
disciplinary.
counsel, but would you agree that in the withdrawal notice, all he had to do was to just mention that he couldn't get the, his representation of her could not continue because of some difficulty that they were having. He did not have to disclose that information in the withdrawal notice. And the withdrawal notice did not equate to representation. He was trying to get out of the case. So to me, it doesn't seem like he had to disclose that information just to get out of the case. Had nothing to do with the representation of her.
Completely disagree. We all practice in different areas. I'm a criminal defense attorney. He practices in immigration. We deal with different agencies and we deal with different courts. What those agencies require of you in order to get out of a case is different. Sure, could he have simply wrote there's a conflict? And maybe USCIS would have come back and said, well, that's not going to be sufficient. We need more. Sure. Could he have said there was a bar complaint? He added the information that he felt he needed to include. Now, is that best practice? Would that be, the information I include in a withdrawal notice or you may include in a withdrawal notice? Perhaps not. But does that mean that he's violated the rule of knowingly revealing secrets? And that's the crux here.
Counsel, the only case you cite in your brief is Gonzalez, right?
Yes, sir.
Okay, and Gonzalez says that counsel who's withdrawing has an affirmative duty, and that is to otherwise endeavor to minimize the possibility of harm. So the burden of showing that it was necessary to or proper to disclose really is on your client. It's not really on the ODC to show that it oughtn't to have been disclosed. And in any case, is there anybody in the world who believes that the disclosure of a mental condition that's been diagnosed and treated to the public at large is a good thing?
Well, I disagree with that. The burden does not shift to me. It is their burden by clear and convincing evidence that a secret was revealed. There was no detriment. As you can see from the timeline, she testified 6 years or 5 years after the withdrawal notice was filed. She got exactly what she wanted. She wanted him to withdraw. He was allowed to withdraw, and she remained in the country to testify. So no detriment was established in any way through any testimony that was presented by disciplinary counsel. Those questions could have been asked, and they were not asked. Your second point is, I'm sorry.
Miss Paulding, are you suggesting that saying to someone or putting out in public a person has a medical diagnosis, and when they're off of their medicine, they act inappropriate and unacceptable, is not something that could be embarrassing to a person and would not cause detriment to a person?
This was not put in public. This is put into a private record through USCIS, in which she had a 6-year file in which I demonstrated through countless exhibits, I think at least 12 exhibits, where that medical diagnosis, the medications that she would be on, the opportunity for relapse, the inability to get treatment, all of those things were already in the file. So I'm not saying that that would not be embarrassing or detrimental, but what I'm saying is that if Mr. Alexei has been having conversations about her mental health with this agency, because it's not like he's revealing these statements to another colleague or another lawyer or in open court. This is the same agency he has been talking to for 6 years about her mental health. And so when he continues to talk about that mental health, it's a history that they are already familiar with.
Excuse me, are you saying it's the same, excuse me, are you saying that the disclosures that were made in the withdrawal notice was given to the same person? If so, where in the record do those facts appear?
It's in the USCIS file. So everything that goes to USCIS is filed to the same organization. So all of your filing go through, that's who you have to withdraw. So when you're filing your B2 visas with USCIS, and I don't have that specific address in front of me, then you're filing your withdrawal notice with that same agency that's handling those B2 visas, because they're the only ones that can allow you to withdraw from the case. So to think that he's putting this on a billboard or having a conversation about this with other people is incorrect. He's talking to the
Each of
one
those times
agency.
those disclosures were made in 2011, 2012, during his representation, did he not get consent from the client on each of those occasions? So why would he not get consent in the withdrawal notice so he could advise her of the harm or the risks that are involved with the disclosure?
I disagree that you don't get to take back consent. If you have authorized me as my client that I can speak to this agency about your mental health, and I've been doing it for 6 years, specifically the condition that was listed in the withdrawal notice and in several of the other letters, you do not need consent every single time you make a filing. She has to file and sign the B2 visa applications. So that is why her signature is on each of those other forms. She doesn't have to sign a withdrawal notice. But I disagree that you need separate consent.
Mr. Walker has a question. Mr.
What about
Walker.
the statement that he made that she was coming to my home residence at 7 a.m. and without appointment demanding actions on her appeal? Had that previously been made to the agency? One. And isn't that a violation of attorney-client confidentiality? He's describing what she came to his home for and what she wanted to discuss, leaving secrets aside. Isn't that a violation of attorney-client privilege?
Well, the hearing committee did not find that there were any confidences. Attorney-client privilege is information that you as a client intend to keep private. If I am at your front door screaming and knocking on your front door for you to open it at 7 o'clock in the morning, I am doing nothing to try to keep my confidences with my attorney private.
Well,
so
If you're asking a question, if you're to Mr. Walker's point, it's not only that she's showing up at his door, but he's also explaining the reason why she's there, which is based on a communication from his client, correct?
Well, there was no information in the record as to whether or not he opened the door, whether he spoke to her, or whether she was speaking through the door.
That doesn't, that's not the point.
He
The point of
disclosed
the
the subject
representation
matter.
that he made was that she was showing up at his door, asking him questions about her appeal. Let's just start from a basic point, since we can't get you to agree to the broader point. Is the basic point of her communicating to him the purpose of her visiting at that moment, is that a client confidence or not?
No, not if she's out in public on his front doorstep. And I believe at this time, my time has expired and I've reserved my remaining.
What if
time.
she's whispering through the door, I'm here because I want to ask you a question about my appeal? Is that a client confidence?
That's facts I don't know. And in fact, the hearing committee did not acknowledge that there were any confidences in this case, and they only focused on secrets.
I'd like you to answer before we move on. I had a two-part question. The first part of which was, did your client have did the respondent's client agree to disclose the statement that I cited, coming to my home residence at 7 a.m.? Had that previously been disclosed, and was that previously on the record?
No, that was not previously in the USCIS record.
Okay.
And Ms. Paulding, don't worry, you'll get your full 5 minutes rebuttal, but a question for you. You mentioned that these were filed, they're not public filings, they're filed in the USCIS portal. But the documents could at any point have become part of a court file, right? If the matter moved on from an administrative setting, it's not subject to protective order.
It is not subject to protective order. I don't know all the details about that appellate process where I can appropriately answer that. All I can tell you is that it was in the USCIS file, which had been tracking since 2011 when he started working on the case.
Okay, thank you. Mr. Metzler.
Thank you, and may it please the board. This case presents a straightforward application of Rule 1.6A. As we've been discussing, in response to a disciplinary complaint, Mr. Alexei lashed out at his client by writing a letter withdrawing from his representation in which he made derogatory, demeaning comments about her. He said that she was harassing him, that she was coming to his house, that she was coming to his office without an appointment. He mentioned the specified medical condition, suggested she might be off her meds, and said he was looking forward to suing her. She was acting irrationally and inappropriately. Those were secrets within the meaning of Rule 1.6b because they were, as counsel admits, they were gained in the professional relationship. And as I think she admitted, she said she's not saying those wouldn't be embarrassing or potentially detrimental statements. I won't hold her to that because it was within argument, but her main argument seems to be that well, the client herself wasn't embarrassed, and we didn't show that that there was actually any detriment followed from these disclosures. But of course, that's not what the rule says. The rule says the disclosure has to be, or information is secret if it would be embarrassing and if it would likely be detrimental to the client, and that requires a forward-looking analysis, and that's for a good reason, right? An attorney.
Yeah, but Mr. Metzler, are you saying, okay, we're just trying to get an understanding here. Counsel said in her argument on behalf of Respondent that the hearing committee's findings were based on inferences it made from the notice to withdraw, and that in the record there was no testimony about whether the client was actually embarrassed, and that the record doesn't support an inference that there was any detriment to her case from the filing. So I guess I have two things. First, can you comment on that?
Sure. So, you know, it seems to me the argument is that, well, you know, that those things matter, and you know, I submit that they don't. Rule 1.6 necessarily is forward-looking. An attorney who is deciding whether to disclose information about his client, well, they can go ask, right? If they ask the client, is it okay? That's going to be covered under 1.6E1. If the client consents with informed consent, then it's permissible to reveal a secret or confidence. But assuming the attorney doesn't do that, the attorney has to make a decision, and he's making the decision before he discloses it. Now, the rule requires him to judge whether the information would be embarrassing or would likely be detrimental. And both of those things apply here. If you look at the cases that the court has decided in Gonzalez and the board opinion in the Yosemite, I think is how you say that, case, they both involve withdrawal letters where the attorney made the same kind of derogatory and demeaning comments about their client. And they both resulted in a finding that the attorney violated 1.6A. The same should be true here. And if you
can you refresh my memory about in those cases, was there actual testimony from the clients? I was embarrassed by this. This was supposed to be confidential.
I believe in, if I'm correct, I believe in Gonzalez, there was a complaint, the client filed a complaint about it. I'm honestly not sure in the Yosemite case, but
Mr. Metzler, is it an objective standard, like whether a reasonable person would be embarrassed?
Yes.
Or do we really have to have a subjective answer to this?
I think we do not. And I think you can see that in the Gonzalez opinion. So in Gonzalez, the court, to be honest, they sort of say, well, this is pretty obviously embarrassing information. And but they went on to say, we don't see how any reasonable person could view it as otherwise. And I think that endorses exactly the kind of standard that we're talking about. An attorney.
So
Miss-
then-
Mr.
so then
Mr.
could-
Ma-
Just a second, Ms. Cassidy, I'm sorry. But so then conversely, you could have a client who files a complaint and says, I was embarrassed by this. And the hearing committee could say, but this was not embarrassing.
I think that's right. And there's like I say, there's a good reason for this, because if the disciplinary rules depend on the sort of vagaries of a client, you could find one attorney would be disciplined because a very sensitive client did not want to have revealed some very mundane information about them, whereas another client is very blasé about their life and doesn't really care.
Well, Mr. Metzler, excuse me, Mr. Metzler, though, how is the respondent's statement of his intent to file a civil action against his client? How is that a secret or a confidence of his clients?
Well, I think you could take them one by one, and if that were the only thing that were revealed, maybe that would be a closer case. But the hearing committee took the statement as a whole, and it's similar again to the other two cases, and said when you're.
But even if we take, excuse me, even if we take it for as a whole, he makes a point that there's harassment in his office and that she's filed a complaint with the ODC, which is it's a fact, right? And that's certainly not within the representation that she filed a complaint with the ODC. Coming to his house at 7 a.m. without an appointment is simply a fact. And then when he talks of her diagnoses, he actually references some documents in the file. So he's pointing the agency to facts that already exist as a reference for his decision. And so even if you take it together, how does this add up to a secret or a confidence?
Well, the idea that these are merely facts that exist, I don't think that can be really considered, because if a client confesses to you that they did the murder, well, that's just a fact too. And so I don't think that's really comes into consideration at all. And as I was starting to say before, the facts here are actually very similar to the two prior cases. And what the court said in Gonzalez is, how can it not be embarrassing when your own lawyer is making this kind of comment against you? He's saying maybe she's off her meds, she's acting irrationally, she's coming to my house and doing all these things. That would be embarrassing, but it could also be detrimental. These decisions in the immigration context are a matter of discretion. And so it could well be that the decision maker, who might be fine with someone staying in the country for medical treatment, might then think that, well, maybe we don't want to let this person stay here if they're going to be out harassing people and causing all sorts of trouble. So I think that the hearing committee was fully correct to say that this would likely be detrimental. And just I want to step back for a moment and talk about in general the idea that a violation of 1.6 depends on the individual client. The rules do not exist just to protect a client. They protect the attorney-client relationship, and more broadly, they protect our our system of justice itself, right? We have confidentiality because clients have to be able to have confidence that when they tell secrets to their lawyers, that those secrets are going to be inviolate. We need clients to speak truthfully to their attorneys so that they can provide the best representation, and the judicial system, therefore, can get accurate information and we come to the best results. If it just depends, if Rule 1.6 just depends on the client, well, then who knows how how an attorney is going to behave. An attorney could say, well, I just didn't think they were going to mind. He seemed pretty okay with whatever fact, and so I thought it would be fine. And maybe for that client it would be, but that would then encourage other attorneys to act that way. It would encourage clients then to not be forthcoming with their attorneys, and chaos. So I think there's a good reason that the Rule 1.6 is phrased the way it is. It is phrased in a forward-looking way. Statements are secrets if they would be embarrassing, if they would likely be detrimental, and that's how you have to look at it. Now, I would like to just take on quickly another few of the arguments in Mr. Alexie's brief. He suggests that this was authorized because he had previously disclosed the medical information in order to pursue her case, and that I think is it's correct that he was allowed to disclose her medical information for that purpose, and there's actually a rule that provides for that. Rule 1.6E4 says if he has a reasonable basis to believe that the disclosure was impliedly authorized in order to carry out the representation, then it's okay. And that exactly describes informing the immigration authorities about a medical condition so that the client can stay in the country to take care of that medical condition. Now, that simply does not apply then to this disclosure.
Counsel, would it simply be enough if in his withdrawal notice, if respondent just stated she intends to file civil action and did not disclose the other information, would that be sufficient to
I think
no violation of the rule?
Right. So I think that so under the specific hypothetical, he would be, I guess, alleging similar to what he said here, right? She has filed a disciplinary complaint, and that has created a conflict that would impede my representation, and therefore I need to withdraw. Mr. Alexie said that he could have done that, and that's, I think, finding of fact 32 from the hearing committee. So I think in your case it would be very similar. That would be a limited disclosure in order to carry out at least the ending of the representation, and it wouldn't go beyond what was necessary. And you can actually see this throughout the parts of 1.6 that allow disclosures. They allow them to the extent reasonably necessary or to the minimum extent necessary. And as I think it was Mr. Tiger said earlier, in this case, Mr. Alexie was withdrawing his representation, and so under Rule 1.16, he had an obligation to minimize the harm that he to the client in doing that, and so he was, I think, obliged to reveal the minimum amount of information necessary to accomplish, and he testified, well, maybe that wouldn't have been enough, maybe they would have asked another question. But even if that were so, it's worth another letter or another conversation or another attempt to maintain client confidences and to not reveal, to not do what he did here, just come out swinging against his client.
Well, Mr. Metzler, did he come out swinging, or did he put facts in there that show that he needs to withdraw because he and his client are now in direct conflict with each other, right? His client's filed a disciplinary report or concern against him. He feels compelled to file a civil action against her because of what he's arguing is his trespass. So could it not be seen that those facts were necessary for the adjudicative body to determine that he now was in conflict with his client and therefore couldn't continue the representation? Much more plain vanilla may not have relayed adequate information to the body adjudicating this to make this assessment?
Well, what the what the rule says is that Rule 1.6A says that an attorney is not allowed to disclose information that would be embarrassing or would likely be detrimental. So with that in mind, even to withdraw, Mr. Alexei had to minimize the amount of disclosure and the potential harm to his client. So you could say a lot more. There could be a very extreme case in which the attorney has to withdraw because he's had death threats and lots of other things. And also there was this disciplinary complaint. Well, the disciplinary complaint actually gets you there. So you don't have to go into these other things. And in fact, you are not allowed to go into those other things. And just to take one last look at the rule. The rule is pretty well thought out. And if you read the whole thing from beginning to end, it clearly shows that the court, I guess the ABA probably had the first version of this rule, but the court adopted it. It really goes through the reasons why you might need to disclose things. If maybe the attorney needs to collect a fee, and so he has to have some litigation. He's going to have something in order to be able to get that fee. And so the rule says, okay, that might be okay. You need to do it.
Let me before you get too far on that. In Gonzalez, the Court of Appeals said that the obligation to maintain confidences and secrets is by turns sacred and controversial. That is to say, it's a fundamental part of the lawyer-client relationship. And yet, ODC asked for a public censure. When the hearing committee comes up with informal admonition, you all acquiesced in that. Why? Can you help us understand why you backed off on the sanction?
Sure. But first, let me tell you that I agree with every word of the Gonzalez opinion about the sanctity of the attorney-client relationship and the requirement to the importance of keeping client secrets. Yes, we asked for an informal admonition because we thought this was serious. Mr. Alexei didn't believe he had done anything wrong.
Initially you asked for public censure, didn't you?
Yes, sorry, I misspoke. We asked for slightly greater than what has been in the discipline that has been imposed in other cases, and we gave reasons for that. The hearing committee disagreed and said, well, this is more in line with those cases than well beyond them. And the cases we had to point to were cases in which informal admonitions were issued, and so we took the decision to not take exception based on the hearing committee's analysis.
Thank you.
So just to wrap up the last thought, which was that
Mr. Messler, I think our understanding of the record collectively is there's 4 statements that respondent included in the withdrawal notice that ODC and the hearing committee found violated his obligations under 1.6. I think you've been asked about parts of them. But there's one, I believe respondent said, and Ms. Cassidy asked you about this. I'm looking forward to file a civil action against the client or any other legal actions to protect my integrity and quiet enjoyment of my private residence. Are we looking at that statement alone or in combination with other things that respondent revealed?
I mean, I think you have to look at it we charged one violation of 1.6A, right? So I think you have to look at the disclosures he made as a whole. So for example, we wouldn't say if he had we wouldn't be here if Mr. Alexei had simply said, my client has filed a disciplinary complaint against me. I don't think I can reasonably continue with this representation. That was included in there. Under the, I think it was Ms. Rice Hicks hypothetical, if the client had said, well, she was going to sue him, that would be a closer case, right? That might be acceptable to show that there was a conflict that required the termination of the representation. But the statements that were actually made don't, and they went well beyond what was necessary. They are exactly the kind of demeaning, derogatory statements that were in Gonzalez, and actually even, I think, worse than in the Yosemite case. I see my time has expired, but I'm happy to answer any questions.
Thank you, Mr. Messler. Ms. Paulding, your time for rebuttal. You have 5 minutes.
I'm not sure why we had a hearing then. Disciplinary counsel is basically saying that the notice standing alone with no other testimony is sufficient to violate this rule, because it's going to be the subjective opinion of disciplinary counsel and this board to decide what the client's secrets are, when that is not the intention whatsoever of the rule. We had a hearing and we called her as a witness, and she had an opportunity to detail over lengthy testimony that she was embarrassed, or that in the 4 years that she had been waiting, it was detrimental to her. And those questions weren't asked of her, because I can only assume that her answer would have been, no, I wasn't. It is very puzzling to me how this withdrawal notice was sent in 2017, and then for 4 years, they did nothing about it. And then we got to the hearing, and they didn't ask the relevant questions that were needed. And to simply say that, oh, well, we don't have the burden, or we don't have to actually prove what a secret is, we can just rely on the collective opinions of the lawyers in the bar and disciplinary counsel and on this board, I think is completely improper. I mean, when you look at Gonzalez, that client was mad. That client hired a new lawyer. That new lawyer said, please do not submit this withdrawal notice with those letters that say that my client wasn't paying you and that she's a lawyer, or that she's a liar, excuse me. And so the client in Gonzalez had things that were communicated to Mr. Gonzalez that she did not want to come forward. And we have had a plethora of opportunities for this client to give reasons for why she didn't want this information to go forward. I am submitting to this board that the disciplinary counsel did not prove by clear and convincing evidence when they had an opportunity to do so. And to simply put our subjective beliefs in it, that maybe this is derogatory and this isn't the best statement to put in a withdrawal notice, completely ignores what the client wanted and what her intentions were. Because if the standard is would be detrimental, well, maybe in 35 years, she gets denied a B2 visa, and then we look back and we say, oh, well, that notice was in there in 2017. It would be endless. Anything could be detrimental. Anything can be embarrassing in today's society. And I think that's a standard that we cannot simply lay our hat on. We have to consider her opinions, her testimony, and the fact that they didn't elicit anything in support of a secret. That's, unless there are any questions.
Wouldn't it be enough, Ms. Paulding, according to Gonzalez, and I hear what you're saying, but, you focus on embarrassed or, demeaned or detrimental. Wouldn't it be enough if the language of the disclosures tended to demean or belittle the client? And that's language from Gonzalez, and that doesn't seem to focus on the feelings of the client necessarily. It looks at the language. It looks at the disclosures, the actual disclosures made, and it seems the Gonzalez court is you look at those to see whether they tend to demean or belittle.
And that's why I think Gonzalez is slightly confusing, because it is different than when the definition of a secret is. If I look at a very specific definition of a secret, then I don't believe that it's met here. But I do acknowledge that Gonzalez seems to take a
You're
broader
saying we should-
viewpoint.
You're saying we should ignore Gonzalez?
I think that if you look at the word secret in Rule 1.6 and you dissect the definition of that in the rule,
We should ignore
Then,
Gonzalez.
I think that you should consider the definition of secret in 1.6 in conjunction with Gonzalez, which are factually two very different cases.
Thank you, Ms. Paulding.
Thank you.
Unless there's anyone else has any questions, we'll just say the case is submitted. Thank you.
Thank you.